I'm so excited for this conversation. I know it's going to be a very lively, newsy, and insightful night, given the fact that we are coming off a day and a week of so many consequential decisions by the court, some that have yet to be decided, or one that's yet to be decided that we're still waiting on, but all of these with wide-reaching and far-reaching impacts for all of us in the years and decades to come. So with that, I will introduce our esteemed panelists here and experts. We have Neil Katyal, a professor of law at Georgetown University, a best-selling New York Times author and a partner at Hogan Lovells. He has argued 51 cases before the U.S. Supreme Court. Melissa Murray, a professor of law at NYU, focusing on constitutional law, family law, and reproductive rights and justice. She is an MSNBC legal analyst and the co-host of a podcast I'm sure many of you have listened to, Strict Scrutiny, a hit podcast about the Supreme Court. She is also a best-selling New York Times author. And last but not least, George Conway, president of the Society for the Rule of Law. This is an organization of conservative and libertarian lawyers and others that he founded in 2018 to address threats to the rule of law in America. He also, as an attorney, successfully argued the securities case Morrison v. National Australia Bank before the Supreme Court in 2010, and also represented Paula Jones in her lawsuit against former President Bill Clinton. So, welcome. Thank you. So I want to start with a very consequential decision that the court made today, and this is this overturning of what's called the Chevron Doctrine. This is a landmark 40-year ruling. It's a backbone principle for how the federal government keeps corporations in check. This ruling was 6-3 down ideological lines, and it's seen as a major blow to the power of federal agencies. So I just want to get each of your reactions, big picture, to the significance of this decision and what the impact is going to be long-term. Neil.
So first of all, thank you for having me. This conference I love. It's one of the few my mom comes to every year. And this panel is just extraordinary, so you're in for a treat. You know, I've been coming to this conference and speaking about the court for a decade, litigating before it for 2. The court's really changed, and this case is a really good illustration. The key principle in our law is what we call stare decisis, respect for precedent, the idea that no current group of justices knows everything, and so you look to the past for guidance, for wisdom, for stability in the law. 2 years ago, the court spit on that doctrine in the Dobbs decision, overturning Roe versus Wade, one of the most canonical precedents of our lifetimes. Today, they did the same thing in another area of law, which sounds arcane, but is at least as important. The Chevron deference doctrine is basically this. Most government rules on you aren't done by Congress. Congress is incapable of legislating. They can't agree on whether the sky is blue. It's all agencies. It's agencies like the Federal Communications Commission regulating your phone bill, or the Department of HHS, Health and Human Services, which is about Medicaid and the Medicaid expansion and the Affordable Care Act, or it's about immigration and DHS and those rules, consumer protection, the Consumer Finance Protection Board, environmental protection, greenhouse gases, ozone protection, all of that's set by the agencies. And what the decision today says is agencies don't have any say over the power they effectively have to regulate this area. There's no, even though they're the experts and understand the nuances, it's up to courts now to decide all this. This is massive deregulation. This is as important as any decision in our lifetimes. It's a total switch to the way our government operates, and it's going to massively deregulate the economy.
Melissa, do you want to jump in on that?
Sure. Also, I want to echo Neil's thanks. Thanks so much for having us. This is a really fantastic conference, and many thanks to Tina, who's done such a great job curating it, and to all of the staff who have done such Herculean work to bring all of this together. This decision will change government as we know it. I can't say it any more plainly than that. The way that most of us experience government is through administrative agencies. If you want a passport, you don't call your congressman. You go to an administrative agency to get your passport. You want to adjust your immigration status, you go to an agency to do that. That is how government works. We live in a sprawling society. You cannot go to Congress for everything. So Congress writes these laws, But in those laws, it delegates authority to the administrative agencies to then make rules for how the statute will actually be administered. And the Chevron Doctrine was decided in 1984. It was done when the Reagan administration was sued for one of the regulations that it made. And the regulation was actually quite deregulatory. It was an environmental regulation that really accrued to the benefit of corporations. The court, in a unanimous decision in 1984, said that in situations where the terms of the statute are ambiguous, the agency gets deference. Courts defer to the agency's interpretation of how the statute should work. The agency gets to resolve the ambiguity. That put a lot of control in the hands of agencies, and it made it easier for agencies to regulate. And for some groups, namely regulated industry, that was a real problem because agencies do lots of things in terms of regulation and make it harder and more difficult and more costly for regulated industries to function. So imagine a world without regulation. It would be better for the corporations, but it might not be better for us, right? So with agency regulations, you serve ordinary people, but you disserve the interests of wealthy conglomerates that would prefer fewer barriers to competition. What this decision does is not only lower the barriers for those corporate interests, it also shifts power from agencies to courts. And right now, the lower federal courts have been stocked over the past 5 years by the Trump administration with movement conservatives who are hostile to the prospect of regulation and who are hungry for deregulation. So now, when these ambiguous statutes present themselves, it's no longer going to be agencies who determine their meaning. It will be courts, and it will largely be courts staffed with judges who are skeptical, indeed hostile, to the prospect of regulation.
So, George, if you could jump in on that and your reaction too, but also it does seem like this is coming off a series of rulings where it seems like the court is indicating that they're trying to maybe take more power away from other agencies. And even Justice Kagan wrote a scathing dissent today accusing her conservative colleagues of forgetting their role in the three branches of government, writing that the majority disdains restraint and grasps for power. So what do you make of that in the context of this decision by the court?
In the context of this decision, I respectfully dissent, at least in part. And the reason why I dissent is because what is at issue, or what was at issue in the Chevron decision, was the interpretation of statutes, the interpretation of law as it is passed by Congress. And it is just fundamental, we learned it in law school, that, ever since Marbury against Madison, is the duty in the province of this famous quote, duty in the province of the courts to say what the law is. And it's up to the courts, ultimately. The courts have final say about what Congress says and what the statute says, not some administrative agency which may have an interest in expanding its own power. And what I understand the concerns that there certainly is a deregulatory bent among Republicans and conservatives, and certainly with the Trump administration, and hopefully not with the second Trump administration. The fact is that there still will be deference to findings there should still be deference under the Administrative Procedure Act to the actual findings of fact and findings of I don't mean findings very specifically in like a traffic accident, but the findings about what problems are and the scientific analyses that go into administrative decisions, and also in particular into the rulemaking. But at the end of the day, it's up to the courts to basically say, well, what does this word mean in the context of how the word is used generally, in the context of which it was used, whether it be in the sense of business or in the sense of what Congress was trying to get at. And I think at the end of the day, I don't know that it's going to make that much of a difference whether or not the courts apply Chevron or not, because the Supreme Court hasn't really applied Chevron very strongly in a number of years. In fact, it doesn't bother with it. I mean, and the other thing about Chevron is there's just no basis in, if Congress wanted to say that in the Administrative Procedure Act, it could have said that the court should defer, although I'm not sure Congress would have the power to do that. And I think that one of the other things about it is that the Supreme Court, I don't think that it's necessary for the Supreme Court to actually have to, I think the Supreme Court, well, I lost that train of thought, but you get my idea.
Well,
God,
either
that
any
sounds
of you,
familiar from last night.
You heard all this before.
Neil or George, jump in. I mean, do you agree with Melissa's
Like President
point?
Biden, you know.
Exactly. Do you agree with this point that it seems like the court is taking on cases or making rulings that's essentially giving them more power?
Oh, 100%. I mean, look, I don't disagree. I mean, I normally agree with George on almost everything. On this, I do disagree. The question is not, do courts have some role in the interpretation? Of course they do. The question is, particularly in these highly specialized areas, do you want administrative agencies to be deferring to those decisions, or do you think the generalist courts are the ones to do so? The Supreme Court in 1984 said, we're going to defer to agencies in making that decision. That decision in 1984 is one of the most cited decisions ever in American history. It's cited 18,000 times by lower courts, 70 times by the Supreme Court itself, and it is the fabric and basis of a good deal of our regulatory state right now. So what the court's done, and maybe you think it's right, maybe you think it's wrong, but just descriptively, they're basically handing the power to the deregulators.
Now I remember what I was going to say.
for it.
So like Governor, who was the governor of Texas who couldn't get to 5 when he remember? Because I had 5 things.
Right.
I mean, the two things are, one is, I don't think this is a power grab by the Supreme Court. I think that what happened in Chevron was an unjustified giving up of judicial authority. And again, it wasn't based upon anything in the statute. And the other thing about it is it kind of was a decision of a rump court. I mean, they barely had a majority. How many people were on that court? Six. Yeah, it was a 6-person court. It wasn't really well thought through. If you read, when I've read Chevron, I don't practice it the way you do, but I took administrative law many decades ago. I couldn't figure out where the heck they got that from. I understand the logic that, there are all these things going on in these regulatory cases that generalist judges don't understand. But on the other hand, these laws were passed by generalist legislators. And if it's up to the legislators who can actually hear and bring in people to testify to actually be clearer if they really want to grant some authority to a regulatory agency, they can be more specific about it. And that's actually part of the problem, I think, that we're seeing in the Supreme Court and the judiciary these days, precisely because we have this paralysis in the not the executive branch, but the legislative branch, where things can't get passed and people can't. They want to, both the legislative branch and the executive branch love to punt things to the court. And it puts a lot of pressure on the court, and it's bad for the court, it's bad for the judicial system, bad for the rule of law. Example, I think, is the Bumstock case, which we're going to talk about, where, we'll talk about that, but that's an example of where Congress didn't do its job, and now the Supreme Court is getting, attacked for
Melissa's making
not having
faces.
done Congress's job. But okay, we'll
my face has no chills. I've been making this the whole time.
This is what she always does with me.
True. So let me just.
I think she likes me anyway.
I do like you. I don't like this. So. To be really clear, Congress legislates, and they can't see around all corners, so they will write broadly textured legislation. Like the Clean Air Act was written in the 1970s. They could not have contemplated at that time all of the different kinds of threats to air quality, the different pollutants that would emerge. So they write these broad textured statutes. They delegate authority to the administrative agency to, over time, write regulations that are consistent with the principles outlined in the statute. Like, that's how you allow statutes to continue to evolve. You don't have to keep writing new statutes all the time for the same thing. Like, it's the same with the Bumstock case, which I guess we will get to, but when Congress wrote that, they amended it, they did some updates to it, but they didn't know about bump stocks at the time, and they didn't know what a bump stock could do, and so then the agency regulates. So part of this, I don't mean to be bald about it, but the hostility to the administrative state, which is not just visible in this case, but broadly across this term, there were several other cases challenging the authority of administrative agencies, and in almost all of those cases, the authority of the administrative agency was stripped It's a broad attack on the administrative state, and in my view, it reflects a kind of MAGAification of the Supreme Court, where there is, in much the same way you see Marjorie Taylor Greene refusing to refer to Dr. Fauci as a doctor, the court refusing to cede authority to agencies staffed with experts.
And the most interesting thing about it is they say, we know at least as much as these expert agencies. We have the institutional competence to decide. That's what they said today. But like in gerrymandering, which I would have thought they would have had much more competence to decide, they say, oh no, we lack the competence and ability to draw districts and boundaries when it comes to voting. So institutional competence is an argument that's like selectively trotted out when it suits a certain majority.
So I think that this segues well into the next topic I want to bring up, which is that this comes at a time when trust in the court is declining. There's a new poll from AP and the Nork Center for Public Affairs that shows 7 in 10 Americans believe the justices put ideology over impartiality. 7 in 10 Americans. How problematic is this for our country, and how did we get here, Neil?
I think it's really problematic. The court, my entire lifetime, I was born in 1970, it's been a majority Republican appointees my entire life, and most of you in this room. But it's a different form of conservative now than before. It's a type of conservative that is a bit more out of the mainstream with American society. You see that in decisions like Dobbs. You see that in guns. You see that in criminal justice. And so it is, these polls are not surprising.
Melissa?
I think it's hugely problematic for the court to have a public that believes that decisions depend on the ideology of those who occupy the 9 seats on the court. The court is unlike the political branches. It's not like Congress. It doesn't control the power of the purse. It's not like the president. It doesn't command an army. The court has no way to make us obey its decisions other than the fact that we believe what it's doing is legitimate. And so when the court seems illegitimate, whether it's because of ethical lapses or because we view their decisions as unduly political, that's a real problem for the court. They can't get back from that unless they do a real sea change. And the loss of faith from the public is absolutely fatal to the court.
George, you want to jump in?
I concur in the judgment in part on this. I absolutely agree there's a real problem with faith in the court that has been aggravated by these, frankly, atrocious ethical lapses that we have seen among one justice in particular, and then, flags for the other.
I see what you did there.
I see what I did there. I mean, the numbers are just incredible, and I find it just deeply disturbing and disappointing because one of the justices in particular, who seems to fly around the world, is one that I've admired over the years. But that said, I think the problem of politicization of the court is something that has occurred over a long period of time. The court has become too powerful and too important in our lives, in part because of the problem that I mentioned earlier that we kind of discussed with Congress and the executive branch sometimes just abdicating questions to the court. But also I think the court became, and you've heard me say this before, I think on a podcast, and now she's going to make a face. The court became intoxicated with its own power in the 50s, 60s, and 70s. It started by doing absolutely the right thing by restoring the effect of the Reconstruction Amendments that it unjustifiably essentially eviscerated at the end of the 19th century. But then it thought, well, we can solve a lot more problems than that. And then, it went too far, too fast, in too many ways, and into areas where it probably shouldn't have gone into, one of which was, and I don't throw things at me, Roe v. Wade. I mean, Roe v. Wade, the problem with Roe v. Wade was, I think as even Justice Ginsburg wrote, and got in a little trouble at our confirmation hearing about, it went too far, too fast. And I can debate whether or not it actually has any, have never been able to see the basis of it in the Constitution. And that said, that has politicized the court and poisoned the court ever since. And then the court actually compounded the problem 2 years ago by overruling Roe after 49 years, which was absolutely insane. So basically, you know, the court exists under this curse of many, many years of it making itself much more powerful in American life than it ever should have been. And that, no wonder, you know, I mean, you're absolutely right, where, you know, you basically say, well, I mean, we've had presidents, particularly the Republican ones, I concede, you know, appointing justices with the idea, unstated sometimes, or just sub salientio, of overturning particular cases. And, you know, it is a very, very disturbing problem, and I think, it's done a tremendous amount of damage to the court and to the rule of law, and it gets to the point where people are reading things into ordinary decisions on statutory interpretation, reading more politics into things than I think should be, like the bump stock case.
And just to give you a personal reflection on that, you know, when I started arguing before the court, Justice Kennedy and Justice O'Connor were on the court, and every time I stood up at the podium, I honestly had no understanding of what they were going to do in the case. They were total swing votes. They were listening so hard. My brother-in-law, Jeff Rosen, wrote an article about Justice Kennedy called The Agonizer, because he'd agonize visibly at the bench about what he wanted to do. It's not like that anymore. I mean, when I go up to argue now, I pretty much know where most of the justices are on any given case. There may be some in play, and there are some, you know, notable, powerful, you know, counterexamples, like last year when I argued Moore versus Harper, the election case. But for the most part, a lot of the justices aren't in play the way they used to be.
So I agree with almost everything George said and everything that Neil said. Right, George.
You write that down once.
They have, I think it is hard, like, it's easier to tell where they're going to go, and it's much easier to predict what the outcomes are. And I think before, it was just much harder. The swing justices truly were swing justices, and they were also more in the middle, right? I mean, so the middle of the court has really moved to the right, and that makes predictability much easier in a lot of ways. You know, I want to take issue with George's assessment of the Warren Court in the 1950s and the 1960s, and the Burger Court in the 1970s. I mean, it's kind of ludicrous to think of the court as being high on the narcotic of women's rights, right? I mean, like, that was, you're right, and you rightly note that the court was making good on the promise of the Reconstruction Amendments, of what I assume you're referring to in Brown. Yep. Same idea for some of these other decisions. And again, Roe was actually less contentious in 1973 than Brown was in 1954. Right? We would never say today that Brown was wrongly decided, yet the South was in open defiance of Brown. In 1973, when Roe was decided by a 7-2 court, written by a Republican justice, no one said much about anything. The big news story on January 22nd, 1973, when Roe was announced, was that LBJ died. It wasn't that the court had decided this right. It is only later, through politics and because of the desire to realign the Republican Party and siphon off votes from both the South and the upper Midwest, that abortion becomes a wedge issue. It becomes politicized. It wasn't politicized. They weren't out in front of the people. And Justice Ginsburg noted that her objections, so she did talk about the court being too far in front, but her biggest objection was that the decision was rooted improperly, she thought, in substantive due process, when it should have reflected a commitment to women's equality.
And I agree again that Justice Ginsburg was right on that. But on the other hand, she also did make an extensive point in that very same law review article, which I commend because it's fascinating to read it, you know, 30 years down the road. What Roe did, and the way Roe did it, is even if you assume that there is that abortion is implicated in the Constitution in some way, even though there's no real textual basis for it or no historical basis for it, what Roe did was essentially legislative. I mean, it answered, and it's actually doing what the court may be trying to do in this immunity case, and what's taking them so long, is they're trying to answer all questions at once for all hypotheticals. And what they did in Roe, which was the problem with it, I think, ultimately, not just the question of whether or not there was a textual or historical or structural basis, the standard ways that people, you don't have to be an originalist to believe this, understood how you interpret the Constitution. Roe was essentially a very, very detailed statute of what could be done at each stage of the pregnancy, even though, it was really, it wasn't just deciding one case, it was trying to decide every possible case that could come out of the 50 different abortion regimes that existed in the United States. And I think that was ultimately, cast, a very dark shadow on the court. And I think that's what contributed to the politicization of the court that exists to this day.
George, I want to ask you about, because you basically brought up Justice Clarence Thomas. Do you think he should have recused himself from some of these cases, these Trump cases?
I don't know that he should. It was necessary for him to recuse himself from the January 6th case, because I don't think there's any indication that Mrs. Thomas did anything of any sort that would render her wait for the rest. Wait for the rest. You'll like what I'm about to say. You gotta wait for the whole answer. I don't know that I think you can make an argument for recusal. I think the argument for recusal actually is much stronger when you drive home at night from the Supreme Court and there's this upside down American flag, and you drive to your beach house and there's this, whatever it is, that
Appeal
tree
to
flag.
heaven. Appeal to heaven.
I mean, that I think is a stronger real. But I will say this about Justice Thomas. I think there should be a criminal investigation. I've said that. I think that, I knew you'd like that. But I'm not saying that because I'm trying to please you. I just can't, it's absolutely the amount of money involved and the failure to disclose those amounts. People go to jail all the time for making false statements to the government under 18 U.S.C. 1001 and a whole bunch of other federal statutes. And those disclosures were just, they weren't just false. Oh, I forgot to add in the vase that somebody gave me when they came over for Thanksgiving dinner. This is just millions of dollars of stuff. And those documents, which get filed with the federal government, were false. And if I were, I think of poor Abe Fortas. I don't know how many people know that history of Abe Fortas. He resigned from the bench for basically, even if you inflation adjust the money he was getting from that guy in New York, is nothing compared to what Clarence Thomas has taken. And it pains me to say this. I like Justice Thomas personally. I've met Justice Thomas. I've met Mrs. Thomas. I've got, and they're very personable. They're very. Okay. I get flack and forth. This is what happens to me. Everybody hates me. No. But anyway,
Melissa, we're going to move on to, unless you wanted to jump in on this one.
I agree with everything you say. I think the failure to disclose those things, it's a real ethical lapse. I want to make clear, it doesn't really matter whether Justice Thomas or even if Mrs. Thomas is actually actively involved in a coup or an attempted coup, but it is the appearance, right? The optics. Like, everyone who's a lawyer understands that often the bigger issue is that you don't appear to be impartial, and that's especially true of the court. And I don't want to be in the business of saying that the spouses of Supreme Court justices can't have jobs and they can't do things, and they're essentially appendages of their partners. But when your partner is a member of the highest court in the land, you have to make some adjustments in order to be respectful of their position and to facilitate their position. Like Thurgood Marshall's wife, Cissy Marshall, they enjoyed a very active life, a social life, when he was the head of the NAACP Legal Defense Fund. When he became a justice and they moved to Washington when he became Solicitor General, and then when he became a justice, they saw their social life completely retract because they couldn't socialize with all of the people they'd socialized with before because they were likely to be before the court. Right now, no one on the court is thinking about that. We have Justice Alito giving interviews to a lawyer/journalist who later came before the court or was on one of the briefs in a case that was before the court this term. We have justices going salmon fishing with individuals who may have business before the court. Their spouses are doing business with people who routinely come before the court. The appearance is terrible, and they have to understand that. And it looks like everyone else is playing by the rules, but the people who are ostensibly making the rules that we all have to live by don't play by the same rules.
Can I throw in? Or
Yes,
move to the
but
next topic?
I feel like I'm moderating a presidential debate. 30 seconds.
Okay,
I would.
And Melissa's got an absolutely good point there, because section, what is it, 455 of the Judicial Code talks about not just actual conflicts, but the appearance of impropriety. And the other point I would make about this is that it is just upside down that the Supreme Court has no ethical rules applying to it, because, not just because it decides important cases like this case overruling Chevron and abortion and all these hot button cases that they have a higher concentration of than any other court in the nation. But when you argue a case, as Neil has probably argued 10,000 cases in the courts of appeals, they know who the parties are in those cases. All right, so basically when they look at the disqualification sheets, they say, oh, it's Acme Company versus Smith. Oh, I have stock in Acme Company, boom. The problem in the Supreme Court is that, on my case, you mentioned my case, National Australia Bank, I represented a foreign bank, and the federal securities laws applied to the trading of foreign corporations. There were dozens upon dozens of companies throughout the world who may have had, who had a financial interest in this case, and they wouldn't be listed on any sheet, any disqualification sheet. The Supreme Court, precisely because it decides so many cases that don't just involve the interests of the parties at hand, needs to have a much stricter code of ethics than any other court in this country.
So, Neil, I'm going to come to you for this one. Let's talk about this Trump immunity case. This is about whether former President Donald Trump is or isn't immune from prosecution in the election interference case. What is going on that we don't have a decision? What's happening?
Well, we have no idea. The court is a black box, except for when they leak opinions or mistakenly post them on their website. Neither of those has appeared to have happened here. So, look, this case asks the question, which to almost ask it is to answer it. If a president violates the criminal law as a sitting president, is he immune from the reach of the criminal law and prosecution afterwards? And no president in our history has ever taken this view, at least while sitting president. I guess, Richard Nixon gave an interview in 1977 in which he said, if the president does it, it's not illegal, which I've taught constitutional law 20 times. I start my class with that quote, and everyone thought it's just preposterous. It's the most ridiculous statement because, of course, the entire American Constitution rebels against that idea. That's what our founders were all about saying no one was above the law. But here you've got Donald Trump coming along and saying this. It was rejected by the trial court resoundingly, rejected by the Court of Appeals with a very prominent conservative judge on the panel saying Trump's absolutely wrong. And then it goes to the Supreme Court where they've slow-walked this thing, taking a long time for briefing, a long time for argument, and now a long time for a decision. I was at the argument. It was about 4 hours long. I don't think it went well for Donald Trump. So I'm expecting on Monday, this is the decision we're waiting on, and I'm expecting on Monday that Trump will lose and that the court will say that he is not absolutely immune. There may be some pockets in which there is some immunity for him, and for other presidents, but for the most part, I do expect it to be a loss. Now, why do I think that? Because at the argument, Justice Sotomayor asked Trump's lawyer pretty early on a question, which was, in the Court of Appeals, you told us that that Trump's position was that he could go and assassinate his political rival, Joe Biden, and order Navy SEAL Team 6 to do it, and that wouldn't be a violation of the law. And was that right? And the lawyer basically said, yes, that's our position. To say that is it is ridiculous. And Justice Barrett right away just popped up, eyes opened, and I saw between that body language and the Chief's, I thought that it looked that way. Now, of course, anything can happen in the deliberation in the months to come, but I expect there will be a loss for Trump, but unfortunately for those of us who believe in the rule of law, a loss that comes so late in the process, he can't be largely tried before the November election. And all this information that Jack Smith, the prosecutor, has uncovered, which only he has, the American public's never seen it, we will not see before the election.
You disagree, Melissa?
A little bit. I don't know that I took the same thing away from oral argument that you did. I do remember that exchange with Justice Sotomayor and then Justice Barrett also going forward with that colloquy. And I think Justice Barrett has been actually quite surprising in sort of her unwillingness to be coup forward in the way that some of her conservative colleagues have been. Her dissent in the Fisher case today, I think, was really striking in that regard. I took from that oral argument that there were definitely pockets of the court who very much wanted to carve out some pockets of immunity for the former president. And I think they will write an opinion. Justice Gorsuch said it would be an opinion for the ages. I mean, it's certainly taken ages to get there. And it will be a banger, I'm sure. I don't think it matters, though, and I think Neil is exactly right on that account. That's an opinion that we will teach in constitutional law, and I guess now we'll know what the contours of criminal immunity are for the president. But as a practical matter, this court immunized Donald Trump from criminal liability on the January 6th election interference case when they granted certiorari in this case and then delayed the oral argument until April 25th, the very last day, and then they're now waiting until the very last day of the term to issue a decision. Jack Smith asked the court in December to bypass the DC Circuit. It's like, so, cert before judgment, before the appellate court has intervened, which happens a lot in other cases where the court is hot to trot to get to an issue, including, for example, that EMTALA case, the Idaho case. They do this all of the time. Here, though, the court was like, no, let the DC Circuit get to it. And the DC Circuit heard oral argument in January. They took about a month to write the opinion, wrote a very comprehensive opinion in which they painstakingly reviewed every claim that Donald Trump's lawyers made, even the ones that were specious to the point of being stupid. And they took those seriously.
They're being kind.
But they took those seriously, and I think they did so because they thought, okay, we are serving this up to the court.
Yeah, they wanted to wrap it all up so they wouldn't...
And summarily affirm it, and the court was like, no, we've got more to say. And so I think the court always knew it was going to get to this, and if they did, they should have taken it in December and given the American people an opportunity to know what is actually going on in this trial, what evidence the government has against Donald Trump, and to actually have accountability before a jury of his peers.
Well, I basically agree with everybody here.
Okay.
I agree with Neil that I think the decision is going to come out very badly for Donald Trump. I do think that. I read the exchanges at oral argument quite the same way. But I also think that they shouldn't have taken the case. I think if they were going to take the case, absolutely, Melissa's right, they should have taken it before judgment. They seem, I mean, it amazes me. I hadn't really read the Idaho case until it came out before it came out. The notion that they granted cert before judgment in that case and not in this case that they were ultimately decided to, it's just, to me, is absolutely insane. And when they failed to grant cert before judgment in the Trump case, I thought it was like, well, maybe they're just going to it's such an easy case, they're going to let the DC Circuit decide it, and then, they can always hear the appeal from the criminal conviction. And decide the immunity case at that point. But they didn't do that. They decided to take it after letting it go through the Court of Appeals, notwithstanding the fact that this is one of the most important criminal cases since the trial of Aaron Burr. It's probably the most important criminal case in the history of the United States. And then they took it, and then they took their sweet time about it. Now that said, I don't think they did what they did in terms of the timing to give Donald Trump some kind of a timing advantage with respect to this trial. Actually,
You're losing him, George.
I lose him. I get him back. I lose him. I get him back. Look, I just tell you what I think. I'm maybe wrong half the time, but anyway, I think what they did here, it's a problem that this court has. I mean, this court, again, thinks of itself as this court that has to decide everything and make everything perfect and answer questions that are not presented in the case. And so they were hung up at this argument, the way I read the argument, about hypotheticals that have nothing to do with the actual raw fact of a president of the United States attempting to extend his term of office after losing a presidential election. And but that said, I mean, this is not an easy, trying to decipher and trying to delineate what protections the president should have from prosecution for official acts, which, there has to be some. I mean, I agree with Professor Trevor Morrison of NYU. He is no conservative, he's a liberal. You could imagine some bizarre circumstances where, I don't know, a Republican Congress under Speaker Marjorie Taylor Greene passes a law basically saying that if the current president, Kamala Harris, does not submit a balanced budget without typos in it by X date, she shall be subject to 50 years in jail after she leaves office. Okay, that would be insane. There would be some insane hypothetical circumstances that would go into it in the way Trevor Morrison put it was, like, this Youngstown, I may have been getting too deep into this Youngstown Sheet and Sawyer Company, the steel seizure case that some people may remember from
George, I'm going to interrupt you because I'm looking at the clock and we have so much more to get. I'm sorry. We have so much more to get to. I want to talk about abortion, but do you have a quick thing you want to weigh on?
Here's just perhaps a more anodyne reason for why it's taking so long, leaving aside the fact that maybe there's some strategery and having it play out for so long. And I think the Chief Justice is genuinely demanding unanimity in this decision and in the judgment, at least. And then there will be, as we've seen in a lot of the unanimous decisions this term, even though they're unanimous in the judgment, they don't necessarily agree on all aspects of the reasoning. So there are lots of concurrences and partial concurrences and dissents, and that takes a long time to circulate and then get out.
So, Melissa, I'm going to direct this question first to you, and we'll have to be quick with this, and because I want to open up to questions for all of you, but I want to get big picture thoughts from you guys. But Melissa, with abortion, the two cases we've seen here with the Idaho decision to temporarily allow emergency abortions there, and also the mifepristone decision, should these be seen as a win for abortion rights, or how should we see them?
No, these are not wins for abortion rights, full stop. So, yes, they're not wins. In the mifepristone case, the court simply said that the pro-life doctors who brought this case didn't have standing. They were the wrong plaintiffs to bring this case because they had never been injured by the FDA's regulation of mifepristone. That doesn't mean they got to the merits of whether the FDA had properly regulated mifepristone or whether it had exceeded its authority as an agency to regulate mifepristone. It just dealt with the jurisdictional question. That means that some other plaintiff with a better claim, like a state perhaps, could come back in the future, maybe after this election, when people aren't quite so exercised about abortion rights, and the court could actually deal with the question of whether the FDA has properly regulated mifepristone. The Idaho case is even more striking in my view because, as George noted, the court actually granted cert before judgment. So this was never reviewed by the Ninth Circuit. The court immediately took this up. And that suggested that there were at least 5 people on the court who were hot to trot to take this case, which suggests that there are 5 people for a judgment to hold that the federal law that conflicted with Idaho's abortion ban did not necessarily preempt that abortion ban, as federal laws are typically supposed to do. After the oral argument in the Idaho case, it seemed really clear that there was a quite significant portion of the court that were really skeptical of the federal government's ability to preempt state laws limiting abortion. And again, that would be a sea change in the whole doctrine of federal preemption, whether federal laws that conflict with state laws actually occupy the field and take precedence. The court did something really unusual here. So after 5 months of having this case pending on its docket, it did, which is to say that it dismissed the case on the view that certiorari had been improvidently granted. And typically a dig happens when the court realizes sometime after certiorari is granted that there are changed circumstances or something happens where they just really shouldn't be doing this case. Nothing has changed though. In the Idaho case, women are still being airlifted out of Idaho when they need emergency abortion care. There are still questions about what doctors can do and whether federally funded hospitals can provide this care. Nothing has really changed. In my view, what has changed is that maybe some portion of the court, perhaps led by John Roberts, recognizes that Abortion is a politically salient issue that can galvanize electoral majorities. And we saw in the 2022 midterm elections that women trooped off to the polls with Roe's death on their lips. And the court does not want yet another decision to fuel the march of women back to the polls. They don't want to be in the midst of electoral politics. They want to be outside of the fray. And I think these two decisions that weren't really decisions at all, they will come back to this court eventually. They're jurisdictional questions, get the court out of the way, but leave those decisions for another day, maybe after the election.
I wish we could keep talking about this topic, but I think right now, to be able to open it, I want each of you to go around and please give me your big picture thoughts on what's next for this court and potentially what's at stake with this upcoming election in November for the future of the court.
Well, I think the Chief Justice, cared so much about the institutional legitimacy of the court, trying to steer it a bit to the center, speak with unanimity, all the stuff he said at his confirmation hearing in 2005, it has not gone well for him. And he is losing control of the court. It's moving far to the right of where he is, where the American public is, and it doesn't seem like there's any logical stopping point. Next year, they're going to have an important case on transgender rights. They're going to have other important cases coming before it. They're, like George says, grabbing more and more of the difficult cases for themselves and deciding them, often with 6-3 majorities. I think this is incredibly bad for the country, and I see no solution on the horizon.
That's grim.
So my statement is not about the court, but about the courts writ large, the federal courts. The federal courts, I think, are captured by conservative interests. The Trump administration was not really successful on any domestic agenda item except the federal courts. They managed to stock the lower federal courts with movement conservatives who are very young and very extreme. And we see this in the way the Supreme Court's docket has been shaped this year. A huge portion of the court's docket this year came from the Fifth Circuit, which is perhaps the most extreme intermediate appellate court in the country. The fact that the Fifth Circuit sent so many cases to the court is really interesting because it essentially means that the court has to moderate what the Fifth Circuit does. And that actually serves a purpose for the court. Whenever the court has to tack back from some extreme decision that the Fifth Circuit has made, it allows the court to assume the mantle of moderation, of being sort of in the middle, when in fact, they've just tacked back from something that was so far off the wall that we've still moved to the right. It's just less perceptible than it would have been if you had the lurch that the Fifth Circuit had wanted. So what we are seeing now is the court is moving to the right. It may not be as perceptible in some areas as it is in others, but the fact that the lower federal courts are really out there with some of these decisions, and the court has to correct them, but even as they correct them, they still move to the right, is telling, right? So we are in the middle of a situation where this is not a consensus moderate court. This is a court that is ideologically extreme, and we need to grapple with that.
George.
Well, I mean, there's always going to be times when one particular circuit or two particular circuits kind of gets over one side or the other. I mean, it used to be the Ninth Circuit used to be perceived as like all the crazy left-wing decisions came up, and now it's the Fifth Circuit, all the crazy right-wing decisions came up. As far as the court's concerned, absolutely, because there's you now do have a 6-3 majority of conservatives. The court is moving to the right, but I have to say that maybe I'm hopeful that there will be a movement back, particularly when you see Justice Barrett and you see Chief Justice Roberts on Kavanaugh, not as much as I thought he would be. They have to understand that the most important thing, they have to get the cases right in their own view, and they do have their own philosophical views. They shouldn't be considering electoral politics, but they also need to be incrementalist. I mean, one of the problems that we had, and one of the reasons why we are where we are today, as I said earlier, is the lack of incrementalism. When people, the justices should not be thinking about where they want to move the law 5 years from now. They should be deciding cases now, on the facts now, and not trying to basically pick cases that they think will move the law in the direction that they want to move it, and then answering hypothetical questions in those opinions that will govern future cases. And I think that, I think that the problem is that the court has become too important in American life, and the fact that you have, the Constitution guarantees it, life tenure, it has sort of, is now become this fuel for people thinking, for justices thinking that they can do whatever they want. They're not responsible to anybody. Witness that cocktail party that, where you had a justice spouting off about politics. So that concerns me. I wish there was a solution to it. The only solution I've ever thought, I think might help, but I don't know if it's constitutional, would be a way of basically having not expanding the court, but having a situation where the court varies in size, and you have every 2 years you add somebody to the court, and then the court sits in panels of 9 of the 9 least senior individuals, and then you could swap in one of the older people to fill in a recusal. And basically, so there'd be a regular appointment process to the court I think that would depoliticize some of what's going on. I don't know whether that's constitutional. I think there's an argument it could be, because it could be patterned somewhat after what happens actually in the courts of appeals, where they only sit in panels of 3. But I don't know, that's the only solution I can think of to the modern difficulties of confidence in the court that I can foresee.
Well, let's open it up. This was fascinating. Thank you, guys. And I only have a few minutes, but hopefully we can get a couple questions in here. Right up here up front, I think we have a microphone coming around, so wait for a second.
I like it, though.
I'm with you.
Hi, thank you so much for coming to speak with us today. I have learned so much, and much of it is very scary. So we hear a lot about how this court and the supermajority is unprecedented, but Mr. Conway, you've also alluded to earlier eras of the court, the Warren Court, sometimes being perceived as judicially active, and also I know the Lochner Court the Lochner era court was also seen as very judicially active. Those eras came to an end, and I'm curious if you see any patterns, or is there any precedent for catalyzing the end of a court's era? Whether that pressure can come from the president, like when FDR threatened to pack the court, or whether that pressure comes from the people. What does history tell us about this? So
far, I don't see any pressure. I mean, I do think that President Biden should be effectively running against the court. I think that is from his perspective, the enemy. They are the people who are taking away the rights that he's trying to protect. But I haven't even heard it enunciated really from the Democratic Party. So I don't see, and I certainly don't see any internal movement. I think George is right to say they're grabbing a lot of power. They're not being incrementalist. I totally disagree with him about Roe. I think Roe, you needed to have that kind of broad statement because, as we just saw in yesterday's debate, you have Trump lying, saying Roe versus Wade means you could have late-term abortions in the 3rd trimester and murder babies and stuff like that. The court needed to set basic ground rules there. That's the court, I think, at its finest in doing that. But when you have an individual criminal case, like the January 6th one, I think George is absolutely right to be that incrementalism is the right way to go. Unfortunately, none of that is the conversation at the court right now.
Let's get this woman right here.
Again, thank you so much for what you do here and what you do nationally for the conversation. I'm interested in the Chevron case and how that might apply to issues like the National Environmental Policy Act, NEPA. We are in the middle of oil and gas extraction territories here. We're surrounded by 85% public lands and are very concerned with how those sort of laws that protect air quality, water quality, and our surroundings are administered in the future. So do you believe Chevron affects NEPA?
We have to keep it quick because I'm told that we are basically out of time. So who wants to just jump in?
So just briefly, there are a bunch of regulations promulgated by the EPA under that, and so all of those are now not going to get the same deference they did before. So it could call into question those, just as in every other aspect of administrative regulation that Melissa was talking about.
Unfortunately, we are out of time, but thank you all. I'm sorry we couldn't get to everyone's questions, but you guys were phenomenal and fascinating. Thank you so much for this great discussion. Thank you to all of you. Have a wonderful night.
Thanks for watching. Stay updated about breaking news and top stories on the NBC News app or follow us on social media.